Hi, I'm Steve Carlson. I've been the Minnesota Independence Party candidate for the U.S. House in 2012 in what is now a safe Democrat district, but which used to belong to former presidential candidate Eugene McCarthy. And in 2014, I was elected statewide as the party's nominee for United States Senate against the infamous Al Franken. Now this year, I'm running for president and seeking the restoration of the Independent Party's major political party status. And if I don't win in the Supreme Court or the U.S. Senate, I'm asking independent voters in Minnesota and across the nation to sign a petition to get me on the ballot, or other independents on the ballot. In Minnesota, based on a strong show by Ross Perot in 1992, the Independence Party of Minnesota was founded, sometimes known as the Reform Party. And actually, Donald Trump won the California presidential primary in 2002 with the Reform Party. Jesse Ventura won the Minnesota governor's race in 1998. And I won the statewide party primary in Minnesota to run against the infamous Al Franken for the U.S. Senate in 2014. But that major political party status and the right to put candidates on the general election ballot through party primaries, usually at the top of the ballot, was withdrawn as a result of a series of unconstitutional actions beginning in 2012, which Minnesota courts refused to correct, until under assault by the Minnesota Democrats and Minnesota Republicans, our candidates, for the first time since the party was founded by the Ross Perot movement in 1992, all fell below 5%. That was the result of an invalid, unconstitutional election. Problem, which is before the U.S. Supreme Court, and it's case number 15-6205, Carlson versus Mark Dayton, Governor et al., really started when I began to speak out against unconstitutional gender, race, homosexual, and ethnic quotas imposed by the state of Minnesota in support of the DFL party. As a result of that, my access to voter email addresses in my congressional district was taken away at the final days and weeks of the general election. This resulted in election contests under Minnesota law in 2012 and 2014, where you challenge and contest the conduct of that election and the results of that election. Now, this trampling of the civil rights of independent voters, as clearly stated by the Supreme Court in 1983 in the case of the independent presidential campaign of John B. Anderson, is a clear violation of the freedom to associate as independent voters to put a candidate on the general election ballot against the two big national parties. That's in the First Amendment. And Minnesota and the Democrats, who have controlled all of the state's positions as governor, like Chief Elections Officer, called Secretary of State, that's Mark Ritchie, and Minnesota Attorney General, Lori Swanson, the DFLer, have been violating many U.S. constitutional provisions, as well as Minnesota election law, in order to destroy intentionally the Minnesota Independence Party, which is really the strongest vehicle in the nation structurally for independent voters to associate and put candidates on the general election ballot against the Democrats and Republicans. Those two party establishments hate it. And Donald Trump is experiencing this right now. This lawsuit, this petition for certiorari to the United States Supreme Court, has grown out of the state of Minnesota, including Minnesota state courts, blocking of election contests, which, as I point out here, are required by the United States Constitution in Minnesota. Contest procedures vary slightly from state to state. The suit requests a number of things, focusing on the need for the governor to follow state law and allow the contest to proceed. Since he illegally issued Al Franken an election certificate in violation of the rules of the U.S. Senate, this was a Senate race, and the senators are actually the sole judges of the contest. And Minnesota judges and officials conspired to usurp the Senate's power and block the procedures required under Article 1, Section 4 of the U.S. Constitution. I ask that the IP major party status be restored and that the contest proceed by continuing to collect evidence in Minnesota State Court to send to the U.S. Senate so that the Senate can carry out their duty under the Constitution, including their duty to guarantee Minnesota a Republican form of government with free and fair elections. Here's the actual statement of the case as submitted to the U.S. Supreme Court. I believe it is clear and clearly warrants the granting of the petition for certiorari to Minnesota to review the state court's actions and the state's actions and command the governor and other officials to follow Minnesota election law and the U.S. Constitution to restore free and fair elections in Minnesota. So I begin here. Statement of the case. This petition for certiorari to the Minnesota Supreme Court is from, which I sometimes just call the Minnesota Court, is from an election contest, sometimes just call that a contest, for a congressional office under Minnesota Statutes 209-12, initiated by that court, initiated by that court, which was aborted by the illegal issuance by Governor Mark Dayton, the Secretary of State Mark Ritchie, of Al Franken's election certificate while that election contest was still pending. The contest alleged that Franken received the highest number of votes legally cast as a result of an invalid election, involving serious, deliberate, and material violations of election law, including the U.S. Constitution, and that one of the results of this corrupt election was the wrongful decertification of the Minnesota Independence Party, whose 2014 nominee for U.S. Senate petitioner is, as a Minnesota major political party. And after the wrongful issuance of the certificate and the refusal to allow the evidence against Franken's right to office and of the corruption of the election, and attempts to void the proceedings by the three-judge panel because it facilitated this, and after this was on appeal to the Minnesota Supreme Court, petitioner filed an elections petition under Minnesota Statutes 204B.44 with that court, asserting Governor Dayton and Secretary of State Mark Ritchie, now replaced by Steve Simon, had a present legal duty to withdraw that certificate and continue the contest to its conclusion, and then recertify the U.S. Senator from Minnesota. All attempts to correct the situation at the highest state court were dismissed and denied. The contest, for whom only the U.S. Senate themselves are the judges, is stalled, and Al Franken remains a current senator on the basis of a deliberate violation of Minnesota law and the U.S. Constitution and an invalid election certificate. On December 2nd, 2014, petitioner, as an eligible voter and candidate for office, filed a notice of contest in the matter of the contest of the general election held on November 4th, 2014, for the purpose of electing a United States Senator from the state of Minnesota. That is 62-CV-14-7915, 2nd District, 2015, because it was determined in 2015. Under Minnesota Statutes 209.12, Congressional Office, the contest statute, no filing fee is required for filing this, and it was filed with the Ramsey County District Court, who was bound to transmit it to the Chief Justice of the Minnesota Supreme Court. And that is under Minnesota Statutes 209.045. She, in turn, was bound by the same statute to appoint a three-judge panel to carry out the provisions of the contest statute, which for this contest required only and allowed only that, quote, the judge trying the proceedings shall make findings of fact and conclusions of law upon that question, on the accuracy of the vote count, which was not contested, evidence on any other points specified in the notice of contest, including but not limited to the question of the right of any person to nomination or office on the ground of deliberate, serious, and material violation of the provisions of the Minnesota election law must be taken and preserved by the judge, trying the contest or by some person appointed by the judge for that purpose, but the judge shall make no findings or conclusion on those points. After the time for appeal has expired, or in case of an appeal after the final judicial determination of the contest, upon application of either party to the contest, the court administrator of the district court shall promptly certify and forward the files and records of the proceeding with all the evidence taken to the presiding officer of the Senate or the House of Representatives of the United States. That's quoting directly from Minnesota Statutes 209:12, Congressional Office Election Contest. It's different than others. But before the contest was even finally determined by the three-judge panel, before any time for appeal had expired, Governor Dayton issued Al Franken an unlawful election certificate, countersigned by Secretary of State Mark Ritchie. This case seeks, inter alia, to withdraw that certificate and require the recertification of Al Franken to the U.S. Senate for that body to take what action they see fit in their duty to guarantee Minnesota a Republican form of government. And that's Article 4, Section 4, Clause 1, U.S. Constitution Guarantee Clause. Petitioner Stephen Wayne Carlson has run in 4 federal elections, including the current one, on the general ballot. This one I'm not yet on the general ballot, but I probably should have said 3 federal elections on the general ballot as the nominee of the Minnesota Independence Party. Most recently, I have announced and am actively campaigning for president in 2016 with a website and with social media, Twitter and Facebook, including YouTube videos. However, I have sought no finances in 2012 and 2014 and raised none in 2010. This is the same strategy I employed in the 2014 race against Al Franken. And this is how I won the statewide primary against the endorsed candidate of my party, Kevin Terrell, without raising money. My party fell short of having a candidate achieve 5% in a statewide race, and therefore is eliminated as a major political party if the results of that race are accepted as valid, which I have contested they are not, because of the unconstitutional practices and violations of the state's congressional election laws beginning in 2012 against Betty McCollum, Minnesota Congressional District 4, and in the 2014 race against Franken. Unlike my House races against McCollum in 2010 and 2012, in 2014, the Democrats and Republicans refused to allow me in the public broadcast U.S. Senate debates with Al Franken and Mike McFadden. And I had little choice but to fight back through the FCC, Federal Communications Commission, and the courts, including a last-minute attempt to get an injunction from Justice Breyer. I intend to run in a primary if I can force, through litigation, including Senate action, Minnesota to restore the major political party status. Then if I were to win the Minnesota primary, I would seek to get more than 5%, and actually I would seek to win in Minnesota and other states. Were I to get more than 5% of the turnout in Minnesota, the Minnesota Independence Party would continue as a major political party after 2016 for at least 4 years. The state of Minnesota and the Minnesota Supreme Court have taken a series of actions to heavily burden the core rights of independent voters, which I am, our candidates and our parties, including the Minnesota Independence Party. I am also identified as a Tea Party candidate. On December 2nd, 2014, I filed a timely contest challenging election practices, omissions, and failures and refusals by the state. Refusals by the state. The Minnesota courts have a very specific function under the Minnesota Congressional Office Contest Statute. That's Minnesota Statutes 209.12, Minnesota Statutes 209.02, and 209.145. This says what the courts are to do. That is to address points other than who had the highest number of votes legally cast and is therefore entitled to receive the certificate of election, but it's told during the pendency of a contest. And because of Article 1, Section 5, the U.S. Constitution, no Minnesota court can act as the judge of any of these points in Minnesota Statutes 209-12. And actually, they can't even be the final judge of the election results. Those have to be judged by the U.S. Senate itself. However, Minnesota courts can act in aid of the Congress, and that is their role. In other words, even in looking at the canvassing board results and making any findings, conclusions of law, and that still has to be forwarded to the U.S. Senate if there is a contest, and they make the decision. Now, at the urging of Al Franken and of Lori Swanson on behalf, she's the Attorney General, on behalf of Mark Ritchie, Minnesota courts took a quite different role, and in their own courts, that is to say before their own judges, reached their own legal conclusions which cut out the constitutional role of Congress and usurped Congress's power. This happened in both 2014 and in 2012 when the controversy first started. As I explained, in violation of Minnesota state election law prescribing the manner of selecting a U.S. Senator required under Article 1, Sections 4 and 5, and while my contest was pending, on December 19th, Governor Dayton, notwithstanding the tolling provision under 204C.40 Subdivision 2, released Franken's election certificate while the contest was pending. This violation was admitted by Secretary Ritchie's brief filed January 5th, 2015, with the Minnesota High Court arguing, for the reasons provided above, the governor and secretary correctly, they say, issued a certificate of election to Senator Franken on December 19th, 2014. In the same submission, Secretary Ritchie argued, for the reasons provided above, the governor and secretary correctly issued a certificate of election to Senator Franken on December 19th, 2014. Although the Minnesota court solicited this brief because there was a question about the legality of the governor's action, the court never issued an opinion on this matter. However, the petition I filed with the court on April 27, 2015, cited a present legal duty for the governor and secretary to withdraw that election certificate because in point of law it is very definitely a violation of Minnesota law, and so Article 1, Section 4 of the Constitution. But Chief Justice Gildea's challenged dismissal of my petition completely omits any acknowledgement that the question has even been raised, that I even raised the question in my April 27 petition. And this was challenged in the petition for a hearing, which was denied June 15, 2015, and challenged here. Gildea also completely omitted my raising federal constitutional questions. Furthermore, Governor Dayton and the legislature as much as acknowledged that the 2014 statute 204C.40 Subdivision 2 was violated because within less than a month of my filing this petition, rather than getting the Franken certificate withdrawn, Governor Dayton signed a law repealing this tolling provision. Moreover, the new federal legislative contest tolling provision now deviates from the state legislative contest provision because the voters, who are just as individuals, have more protection of the integrity of a state election than of a federal one. For under Dayton's new law, he doesn't have to wait for any contest for a federal election to issue certificates to Washington. He does have to wait for a district court to determine a contest before issuing a state legislative certificate. Nonetheless, for purposes, and by the way, this protects the legislature themselves. So for themselves, they want a contest provision and tolling because they are the sole judges. But they voted, and the governor agreed to cut off the sole judge status of the United States Senate or the U.S. House. So, but nonetheless, for purposes of this contest, under consideration at this court, The 2014 version is the one whose effect is being reviewed and which the petition asks be applied. This is consistent with Article 1, Section 4, which refers to the prescribed manner, that is to say, written in advance, which the state was and is bound to follow with respect to collecting and releasing the evidence to the U.S. Senate of the conduct of the 2014 election. Thus, the petition for certiorari to the state of Minnesota and Supreme Court grows out of the failure and refusal of duty by the Minnesota court, duty prescribed by the Minnesota legislature as the manner of electing members of Congress. In 2014, the U.S. Senate, a statewide office. And out of violations of federal and state election law in that Minnesota federal election. The failure and refusal of the Minnesota court in 2014, which gave rise to the election contest timely filed December 2nd, 2014, and the election petition filed 2015, is a continuation of a virtually identical failure in the 2012 U.S. House race in an election litigation petitioner also brought at the end of that 2012 race. The additions in 2014, since these claims were not addressed and redress unconstitutionally barred by the Minnesota courts, since our claims of being barred from the public broadcast debates, which violates the First Amendment and equal time requirements. Although I was a legally qualified candidate for the same office as Al Franken and Mike McFadden, and also a major political party nominee elected in a statewide primary election by independent voters, voting in the primary of the Minnesota Independence Party, and claims that the Minnesota courts were violating the Constitution and Minnesota election law by not hearing and determining these claims when brought before them under Minnesota statutes 204B.44, the election petition, and the election contest statute, Minnesota statutes 209.12, and by in fact actually blocking these claims from ever reaching their true judges, the U.S. House of Representatives in 2012 and the Senate in 2014. The two chambers of Congress are two of the bodies of the United States who are to guarantee the Republican form of government to the people of Minnesota as a right and privilege of being a U.S. citizen. And the Minnesota courts deliberately joined the DFL and DFL officials like Governor Mark Dayton, Attorney General Lori Swanson, and Secretary of State Mark Ritchie to usurp their power and prevent a Republican form of government and free and fair and pure elections in Minnesota for federal office. As a result of this, the practices such as illegal quotas of selecting delegates, withholding of public information, and unlawful exclusion from public broadcast debates have been protected, even nationally, from review by the proper judges in their determination of the qualifications, returns, and elections of members of Congress, which is intended to grow out of the Congressional Election Contest Statute 209.12. Obviously, even while shielding these practices from review and from evaluation under the guarantee of a Republican form of government to the people of Minnesota, the state seems to suggest that the challenge practices do not fall within the ambit of enforcement intended as the other points raised going to the right of office of Senator Franken and Representative McCollum. In order to block each of these properly and timely filed election contests required to ensure and guarantee free, fair, and pure elections and a Republican form of government in Minnesota, an election certificate needed to be presented to each chamber of Congress, the U.S. House of Representatives in 2012 and the U.S. Senate in 2014. That required Governor Mark Dayton, DFL, to get together with Secretary Mark Ritchie, DFL, to prematurely issue them. In turn, the Office of Attorney General Lori Swanson, DFL, took to the courts to defend and protect these claims from ever being examined by the United States. In 2012, Mark Ritchie submitted to the courts that he waited to see if I was going to be allowed to proceed in my election contest, which was filed in Ramsey County District Court timely on December 4th, 2012, although that court refused to allow it to proceed. That is to say, they acted like judges in the contest and the Minnesota Supreme Court acted as judges to refuse to intervene and bar this matter from the U.S. House. They barred the matter from the U.S. House. Now here's some additional facts needed to evaluate this petition. City of Mobile versus Boldin, and Justice Marshall's dissent to seeking proportional representation. I believe this was around 1980. The roots of this contest and this lawsuit actually lie as far back as a suggestion advanced in his unjoined dissent of Justice Thurgood Marshall, which this court described as, quote, much more extreme, unquote, and unconstitutional and baseless in law than the lower courts had advocated in Boldin. You said his position in his dissent, quote, appears to be that every political group, or at least every such group that is in the minority, has a federal constitutional right to elect candidates in proportion to its numbers. Moreover, a political group's right to have its candidates elected is said to be a fundamental interest, the infringement of which may be established without proof that a state has acted with the purpose of impairing anybody's access to the political process. This dissenting opinion finds the right infringed in the present case because no Negro has been elected to the Mobile City Commission. Whatever appeal the dissenting opinion's view may have as a matter of political theory is not the law. The Equal Protection Clause of the 14th Amendment does not require proportional representation as an imperative of political organization. The entitlement that the dissenting opinion assumes to exist simply is not to be found in the Constitution of the United States. Justice Marshall, in dissent, he added, more recently, in White v. Register, 1973, we invalidated the challenged multi-member districting plans because their characteristics, when combined with historical and social factors, had the discriminatory effect of denying the plaintiff Negroes and Mexican Americans equal access to the political process. We stated that it is not enough that the racial group allegedly discriminated against has not had legislative seats in proportion to its voting potential. The plaintiff's burden is to produce evidence to support findings that the political processes leading to nomination and election were not equally open to participation by the group in question, that its members had less opportunity than did other residents in the district to participate in the political processes and to elect legislators of their choice. And goes on Marshall, we held that the three-judge district court had properly applied this standard in invalidating the multi-member districting schemes in the Texas counties of Dallas and Bexar. The district court had determined that the characteristics of the challenged electoral system's multi-member districts, a majority vote requirement for nomination in a primary election, and a rule mandating that a candidate running for a position in a multi-member district must run for a specified place on the ticket, though neither in themselves improper nor invidious, reduced the electoral influence of Negroes and Mexican Americans. The district court identified a number of social and historical factors that, when combined with the Texas electoral structure, resulted in a vote dilution. 1. A history of official racial discrimination in Texas, including discrimination inhibiting the registration, casting of ballots, and political participation of Negroes. 2. Proof that minorities were still suffering the effects of past discrimination. 3. A history of gross underrepresentation of minority interests. 4. Proof of official insensitivity to the needs of minority citizens whose votes were not needed by those in power. 5. The recent use of racial campaign tactics. And 6. A cultural and language barrier inhibiting the participation of Mexican Americans. Based on the totality of circumstances, we affirmed the district court's conclusion that the use of multi-member districts excluded the plaintiffs from effective participation in political life. Now, he goes on then, it is apparent that a showing of discriminatory intent in the creation or maintenance of multi-member districts is as unnecessary after White as it was under our earlier vote dilution decisions. Under this line of cases, an electoral districting plan is invalid if it has the effect of affording an electoral minority less opportunity than other residents in the district to participate in the political processes and to elect legislators of their choice. It is also apparent that the court in White considered equal access to the political process as meaning more than merely allowing the minority the opportunity to vote. White stands for the proposition that an electoral system may not relegate an electoral minority to political impotence by diminishing the importance of its vote. The plurality's approach requiring proof of discriminatory purpose in the present cases, then, is squarely contrary to White and its predecessors. So now I jump to the McGovern-Fraser Commission and how it brought proportional representation. This proportional representation, suggested by Justice Marshall, however, backed by Minnesota state law, has in fact found its way into the election practices in Minnesota. I contend it violates the 15th, 19th, and 14th Amendments U.S. Constitution, and also the First Amendment freedom of association and freedom of political expression. As such, it violates the Guarantee Clause requiring a Republican form of government. It needs to be reviewed by this court, but also must not be blocked from examination by the U.S. Senate and the U.S. House in specific elections through an election contest or Congress's other powers under Article 1, Section 5 of the U.S. Constitution, which also allows for discipline and expulsion. It has a curious Minnesota origin, but it is also the law in several other states, including Texas and California at least, and actually is now gripping the National Democratic Convention, and it is debasing the vote and so is unconstitutional. And I include a lot of these in the appendix, and we'll discuss them in the argument. Now, in 1968, in response to conflict at the Democratic National Convention in Chicago, the DNC chair, Senator Fred Harris, selected a 28-person committee headed by U.S. Representative Don Fraser, DFL, the Congressional District 5 over in Minneapolis in Minnesota, and Senator George McGovern of South Dakota. Fraser was the third big Minnesota player in this 1968 drama, which began with the U.S. Senator Eugene McCarthy of Minnesota, formerly Minnesota CD4, my congressional district, who was not nominated, although he had actively campaigned, while the nomination was given to U.S. Senator Hubert Humphrey, and Vice President, who had not campaigned at all. The party lost badly to Nixon, and in its fundamental soul-searching, decided to change into a demographic-based party. This included commission recommendations of, quote, state organizations to overcome the effects of past discrimination by affirmative steps to encourage representation on the National Convention delegation of minority groups, young people, and women in reasonable relationship to their presence in the population of the state. So then, Minnesota DFL voting rights violations and related state actions. This controversy then was initiated by Representative McCollum in 2012, as she shouted out at a debate with me, "I'm fighting for voting rights," referring to the proposed voter ID amendment requirement, which was on the Minnesota ballot in that election. There was no opportunity for me to challenge that on that stage, and instead I took it up in a Wrap the Vote contest initiative sponsored by Representative Keith Ellison. I recorded Make It Count, which said, "McCollum says she's fighting for voting rights, but her party's setting quotas for blacks and whites. She says she's representing all of Minnesota, but she really represents a Democrat quota. Up here we've always talked about integration, and instead we're spreading quotas all across the nation. So instead of an intelligent conversation, the Democrats use cynical manipulation. Make it count." Any kind of gender or racial steering is just a form of social engineering. We need a social system that's just and fair, but a quota system just gives you a musical chair. The Democratic Party doesn't want your idea. They just want you to sit there for the world to see you. So this was a purely political strategy to debate the issue of voting rights in a congressional House election. And I believe this was appropriate. It did not include litigation of any kind. But this effective rap, which turned the tables on the DFL strategy of attacking voter suppression in requiring voter IDs, was a threat. Because I had been offered by the Office of Secretary of State twice, first in 2010 and then in 2012, the opportunity to purchase all the voter email addresses that were voluntarily submitted to or otherwise collected by Secretary of State Ritchie, because they were not classified as non-public. In fact, Ritchie himself used them to raise funds for himself as a candidate and for his party. I had a social media strategy, including YouTube videos of my debates with McCollum and the Republican. With mass emailing, I could send a link featuring this political criticism of McCollum to nearly every voter in CD4, impacting not only McCollum, but up the line all the way to the incumbent Obama. In fact, through Twitter and LinkedIn, this could have been nationwide, calling into question the Democrats' moral authority in seeking voting rights, when they were denying and abridging the voting rights of white males, and really all groups. Through social engineering, the numbers of minorities in Minnesota were such that really women were the only solid beneficiaries of these quotas, which I will discuss further in the argument section. So I went to the OSS office and paid my money and filled out a form to get the email addresses. But when I uploaded the CD, less than a week before the general election, there were no email addresses. My call to Nancy Bream, the longtime OSS employee who had been offering me and encouraging me to get these email addresses, confused her. She did not know why they weren't there and called Bert Black, OSS counsel. He informed me that Secretary Ritchie intended to deny me these email addresses. She said, "I've just been told that I've been doing it wrong all these years." I asked the grounds, exchanged emails with Black, and within a day, I filed a federal lawsuit seeking to force him to release these. I'm not an attorney, and Chief Judge Michael Davis took control of this suit, which I filed electronically because I had been involved in a series of adversary proceedings because I had been driven into bankruptcy since the 2010 election by the withholding of my emergency unemployment compensation benefits. And this is the subject of Carlson versus MD 13-8124, U.S. Supreme Court 2014. So it was happening during this election. The seizure and sale of my primary residence, garnishing of my wages, etc. I have provided testimony about these events and cases to the three-judge panel for the purpose of going to the U.S. Senate in the election contest I filed December 2nd, 2014. After the 2012 election, and the court's refusal to enjoin OSS to release the email addresses, I researched the law and determined I should seek to void the election by filing an election contest, but that voiding could only be done by the U.S. House of Representatives. I timely filed December 4th, 2012, but the Ramsey County clerk refused to allow it unless I paid $350 or got a judge to grant me IFP. So this stopped the contest from going to the U.S. House because I didn't have $350, especially that afternoon, unexpected, because the election law does not require it, and because the judge inexplicably rejected my rushed IFP application and threatened me if I tried to refile the application. Secretary Ritchie decided to just go ahead and have Governor Dayton sign the election petition for Representative McCollum and forwarded it to the U.S. House. So this is illegal. I then filed an election petition with the Minnesota Supreme Court, no charge, and they refused to allow the election contest to go forward, saying a clerk or judge refusing to allow an election contest to proceed was not a duty concerning an election, just because it's called an election contest. In addition to the email claim, I had added the quotas for endorsements in the DFL, saying as an individual and eligible voter that they violated the Constitution as noted supra. In these two actions, the state and federal, I argued that Anderson versus Celebrezze was there to protect independent voters and candidates and parties, and that my First Amendment rights of freedom of association and political expression were violated by these state actions, including the refusal to allow the contest to go to the Congress. In 2014, as intended, I filed for the U.S. Senate for the Minnesota Independence Party, using my social media strategy, especially YouTube videos distributed by Twitter feeds to all the newspapers throughout the state, rather than contacting all their editors to write opinion pieces. I defeated the party's endorsed candidate for U.S. Senate and became the party's nominee. Before I won, I was polled by Gravis Marketing at 13% of the vote against Franken and McFadden, well ahead of the 5% needed for the Independence Party to survive for the 2016 general election ballot. But I still wanted to get those voter email addresses, this time for the entire state for the Senate contest. Wanted to get in the debates, as I had in the House races in 2010 and 2012, as the major party nominee with equal legal status as the DFL and Republicans. And I wanted to continue to attack the unconstitutionality of these gender, race, and sexual preference quotas, which I felt most Democrat voters do not even realize are being imposed on them, and which I believe violate voting rights by denying and abridging the right to vote based on sex and race, and violating our First Amendment freedom of association and freedom of political expression by socially engineering us, white males and others, out of the party, and distorting the free operation of exchange of ideas, positions, qualifications, and replacing it with preset voting blocks. Since in 2012, the Minnesota Supreme Court said I should not have waited until after the election and bring a 209.12 contest, because apparently the remedy of petition was intended to be brought as quickly as possible and before the election. So I began to prepare a 204B petition to address these matters of the email addresses and the voter quotas and congressional contests in the House and Senate. However, as it became apparent from reading the papers that my party might be excluded from the public broadcast debates both for senator and governor, I needed to determine the state of debates. I was also getting hammered in the press by the disgruntled IP leaders who circulated falsehoods that I thought, for instance, it was a public service to kill Trayvon Martin, the young man tragically killed in Florida in 2011. In fact, I had said Zimmerman performed a valuable public service by guarding his condominium and therefore should not be killed, as so many were saying. I testified to this at the 3-judge panel in the December 2nd election contest. And they also spread around in the media that I argued in defense of former U.S. Senator Todd Akin of Missouri in 2012, when in fact I had stressed in the 2012 NPR State Fair CD4 debate that no one said rape was legitimate. And apparently, liberals felt Akin had maintained that rape is legitimate. I don't know how they could get that idea. But for that reason, I was supposed to be defending him. And I said, and they spread around that I said there is a war on white males. And I was referring to the denials and abridgments of our voting rights across the nation. And this is true. I do believe this. Then a poll was taken stressing my percentage, just at that moment, of primary voters as against Al Franken and Mike McFadden, ignoring the fact that voters for me were not allowed to vote for any Democrat or Republican candidate for any office, reducing my potential voter base. Because I had to go through the FCC first, I could not go immediately to the Minnesota court or this court. I also attended and made movies about the debates for my Senate race, recorded a new song called Heal Thy Nation, and tried to campaign on the issues as well as the wrongful deprivation of rights and independent voters, candidates, and parties. In other words, these lawsuits became part of my campaign. Just before the second 2014 Senate debate, I got the disposition back from the FCC. I was then able to file, because I exhausted administrative requirements, I was then able to file with the Minnesota Supreme Court and file a motion for an injunction to open the October 2014 CBS WCCO debate to the IP, the Independence Party. CBS filed a response, but I did not get anything from the court when I filed this injunction. And she denied the injunction and dismissed the petition. After that, I quickly filed with this court, the U.S. Supreme Court, but apparently did not arrive in time for any potential intervention. After the election and after the IP had fallen short, I got 2.6% or 50,000 votes for U.S. Senate, not counting early voting, which wasn't counted. The top IP vote getter got 4.91%. I had always got 6%, but that was when I was allowed to debate. I then filed the election contest December 4th, 2014. This time, because the Minnesota Supreme Court had to act to set up a 3-judge panel, they did not require a filing fee or IFP, and the panel was set up. But Franken was advised by the Minnesota Supreme Court to file a motion to dismiss the contest, even though this court, or the D.C. Circuit, in Stephen Morgan versus United States of America, in 1986, 801 Fed 2nd, 445, has ruled that the only judges are the U.S. Senate, and specifically not anyone else denominated as judges. The state describes what happened in the Ritchie response to the Minnesota Supreme Court, and how on December 19th, while the contest was pending, Secretary Ritchie got together with Mark Dayton and they sent Franken's election certificate to the U.S. Senate. I then filed a motion to void the proceedings, the whole proceedings, and the panel reconvened, and they determined a number of reasons, acting as judges in the case, why they had had every right to judge and dispose of the case rather than to do their duty and send it to the Senate. I then appealed this to the Minnesota Supreme Court, but Chief Justice Gildea sent me an order by email, even though I had been getting all court correspondence by mail, saying the expedited 10-day time without weekends and holidays was the rule. And I supposedly missed it. I think I counted weekends. While she was sending me this, I filed an election petition saying that because Governor Dayton had released the certificate while the contest was pending back on December 19th, it was unlawfully issued. It had to be withdrawn and recertified, and the contest had to be allowed to go forward. Gildea then dismissed the contest because I had not proved to her why I did not need to meet the accelerated 10-day deadline without holidays and weekends for this appeal, when Franken had already been seated January 6th, so this is like 2 months before. The Minnesota Supreme Court could not stop them from doing that on the 6th, and when furthermore, I had not been served with her order. When I found out what was happening, and timely I filed a petition for rehearing on that dismissal, she apparently was not aware that this was filed in her office, and ruled in dismissing my petition then that I had twice abandoned appeals from the 3-judge panel, when that is not true, but again, the Minnesota courts were acting impermissibly as judges all along, so no matter what they did, it was not allowed by the Constitution. In the meantime, Governor Mark Dayton signed a law repealing the tolling provision, which I believe is perhaps effective for the future, although I think it's unconstitutional, and I am challenging the constitutionality of his action here. She also dismissed my petition, Chief Justice Gildea, saying I had abandoned all my appeals, and so the contest did not need to go forward based on the allegedly unlawful procedure by the Governor and Secretary of State. Then she realized I had not abandoned my appeal and had filed the petition for rehearing, and she promptly denied that, but did not amend her dismissal of the petition to say, well, he actually didn't abandon it, but. And she denied the petition for rehearing on the election petition. I then took appeal to this court through the instant writ of certiorari. And so that basically reviews the facts that are set up. There's a lot more in here, but that will explain to you why the governor has to follow even the Senate rule, which I haven't got into here, but I will in the argument, that this has to be recertified, because he said right in that a cover letter went along with the certificate, and I've submitted all this to the court, that he had followed that law, that tolling provision. In fact, he had to know that he didn't. And I think one reason that he signed a law pretending to get rid of that tolling provision is he doesn't have to follow the law. He doesn't want to follow the law when he's sending out election certificates for Congress. Apparently, he still has to follow it for the state legislature here in Minnesota. So I'm Steve Carlson. I'm running for President of the United States. I'm trying to get the IP, the Independence Party, back on the ballot. And basically, I want the independent movement, or independence movement, to go forward throughout the entire country. And I would like to see all the members of Congress replaced, because it's just not working. And that's something which I'm also trying to do. I hope that you will support this petition. If there's any of you out there who are lawyers, or who are just interested in independent voters, independent parties, maybe Green Party, maybe Libertarian Party, that see how denying these rights hurts everybody. I mean, they've used my 2012 case to deny a petition that the Green Party filed, saying, well, they don't just talk about that. Just like they said they don't talk about anything except who got what votes. And as I discussed this in future videos, including the one that reads to you the argument, the direct and concise argument why the petition should be granted, you'll find out that that Franken himself got involved against Polenti and basically sued himself. Dayton turned around and took Franken's lawyer, who's David Lillyhow, and put him on the Minnesota Supreme Court. So he was sitting there when this got there. So I'm sure that he was not friendly to it at all. Well, actually, he was put there before the Betty McCollum case got there. But he's sitting there, and they just cannot refuse to do their job when, in fact, the Constitution requires the state to set up a prescription of the election laws that need to be followed, the manner of selection, including enforcement of those rules. And so then he went and got them, Franken did, to disregard this, and it's been used ever since. I also want to say one more thing, is that Franken was told by that Supreme Court that he could not have that election certificate until the contest was finished that had been filed by Norm Coleman. And this time, apparently, they've changed their mind, or Governor Dayton has just decided, well, the IP does not deserve the same protections as the Democrats, the DFL, his party, or the GOP, the Minnesota Republicans. And they're all going along with it. Again, I'm Steve Carlson, running for President of the United States. I hope I'll get your support. I hope that you will support my effort to fight for the voting rights of all the independent voters. That is 53% of the voters, if you include those identifying with third parties. We outnumber the Democrats, outnumber the Republicans, and we need those rights, and we've got to restore constitutional order and free and fair elections. Thanks for listening.